So we offer the draft ordinance regarding the Sunny Valley Sand and Gravel Comprehensive Plan. This is the latest version that is hot off the presses as of this morning, is the version you'll be looking at. This is different than what Mr. Chair saw in the last couple of weeks, in that we've made some corrections to the citing, the identifying information that's contained on it, made sure that's exactly accurate. And also there's no reversion clause. My review of the law is that the Court of Appeals would probably not approve that if it were challenged. There had been a clause in the last ordinance, the last version of the ordinance, in which the parcel would revert back to its original zoning classification, exclusive farm use, I believe, in Woodlaw Resource. And so that is no longer in there. The Court of Appeals would, I believe, consider the automatic reversion to be an entirely new designation. It would have to go through the whole process from the start to end. So anyway, that's out of there. In the event that LUBA upholds this in substance, then yes, sooner or later the board will need to pass an ordinance.
My thought is that makes a very good policy if you have a number of LUBA cases or cases before the county that have been appealed to LUBA and remanded and changed. And I'm not familiar with very many, if any, of those. So far, since I've been on the board, maybe there's been 2 cases remanded to LUBA. Neither have been, they have been appealed to LUBA. Neither have been remanded to the county for any substantive change. The ruling of the county stood. And so if I could see that, let's hold off, don't know what we're doing, stuff is changing often from LUBA. It makes no sense to go forward. But we don't have a history of that necessarily as court before, as long as I've been on the board. So the likelihood of a change, all cases are different. This one is substantially different than anything I've heard prior. But be that as it may, I feel pretty confident that the reason we made the decision that we did was founded on stuff that's going to be upheld, and LUBA is going to. I wouldn't be right in my decision if I didn't believe they were going to side with the way we decided. So, having said that, I don't have any reservation for passing this ordinance. LUBA still has their opportunity. They do what they do. Changes, we change our ordinance. Doesn't, stands.
And what happens now as far as the applicant goes? And this is passed on Wednesday.
I don't.
What happens as far as they are now going to? They still have to wait LUBA's response, right?
Yes, all parties in the case are going to be waiting on LUBA's response here. In terms of what happens next procedurally, so if you do advance this to your business meeting on Wednesday, then you would take a vote if you so choose.
The big weight in this argument is LUBA. They have to make some ruling.
Well, Dennis can definitely chime in at any point. I think that an appeal does not automatically stay the applicant's sort of ability to act, right?
No.
It doesn't. So in theory, he can go out and start digging right now, I guess.